A motion in limine is a legal request made before trial to exclude or limit certain evidence or arguments during a trial. The phrase in limine means at the threshold, and it's a way for attorneys to address potential evidentiary issues before they arise at trial. April 9th, 2025, Motion 11, States Motion, Text Messages.
All right, the text messages and testimony.
Thank you, Your Honor. Similar motion by the state asking to bring in the phone records for a DM between 2:10 a.m. and 4:37 a.m. on November 13th, as well as related testimony around that same time between DM and BF. Again, the state submits that there are allowable exceptions to the rule against hearsay to allow these statements to come in. I broke those down in my motion and reply, and the applicable rules for their introduction. This is a much easier piece of evidence in order to be able to present certain time periods and not put in non-hearsay. It's much easier than an audio recording where we would have to redact. But for the messages that DM sends and the messages that BF responds, I think all of those are allowable under the excited utterance, as well as the present sense impression exceptions to the rule against hearsay. If you have any questions about any specific messages.
April 9th, Motion 11, Defense's Response, Text Messages.
Well, Your Honor has our exhibits already related to this, and then in the record were BF's phone activity. I don't need to quote extensively from those. There's a lot more to the text messages than the state has provided to the court, and the lot more makes a difference when you put all of these into context. We went through some of those in our briefing, and the court can see that there's even more when the court looks at the exhibit. I understand from the court's previous statement that the court would accept a complete copy of something versus just pieces of it. Well, I could offer
Qualifies for
it.
the completion doctrine. If it's necessary to explain the prior admitted stuff and it's close enough connection in time and in subject matter, and so there are some questions there. It's not just automatic.
We certainly would understand that we'd have to present some information or cross-examine witnesses about that. The additional bits of information that are contained in that record around that same time frame, though, provide a much better context when we're talking about other communications with social media, with saving pictures, creating new contacts in one's cell phone right before the texting starts between DM and BF, and then subsequent to that, looking at pictures, editing pictures, calling family members. There's a much bigger picture than just this tiny little piece of texting between the two parties there at night. Further context about these messages the court should be aware that it's not just these messages. There's a lot more activity going on between these two people, and it's hard to tell what it is because there's telephone calls and those kinds of activities, as well as going down to one another's room, spending the time together, talking to each other, really take it out of an excited utterance because it's an entire transaction between the two people. It's not just a tiny little piece of context with this group of text messaging. And the whole is what matters here and takes it away from being excited utterances because of the other activities of the two people.
The activities that occur after, so for example, the texts between, at 4:18 or 4:20 or whatever, those aren't affected by the later activities of, surfing Instagram or whatever. And I'll be interested to hear the testimony of the two young ladies because my experience with that age group has shown that where you or I might phone somebody, others might check out their social media to see where they're at or what they're doing, right? And so understanding how they're using those apps is also important.
It is important, and I would refer the court to our affidavit from Mr. Roloff, talking about the Snapchat activity, talking about Instagram, and there's a way to tell if somebody's active on Instagram versus just having it open in the background of their phone, and those are things that were going on, as well as editing pictures. The picture editing happened in those overnight hours. Instagram happened later in that
That
morning.
wouldn't affect the excited utterance and present sense impression of the earlier 4 o'clock text, I guess is my point, because those are afterwards. Those are after they retreated to the room together, and, and what happened there.
Mostly, I agree. There were things that happened right before DM created a new contact at 3:51 in the morning.
Before
There-
anything happened that was of an excited nature.
If you accept the state's timeline for that, and we don't know that yet.
The foundation that will have to be laid, but that's their version of the time events, and that's then the jury's job to figure that out.
Shortly after the last text message, and I'm talking just minutes, DM and BF are doing different things on their phone that night as they get together that night. There's the period of time that they're together in that room, both before there's a break in activity. There's not really a break in DM's phone. That is pretty well continuous. And there is a break for BF, but it starts again right away. So I understand the court's looking at an isolated part of time, but I think it's important to understand what activity was happening leading up to that and what activity happened immediately after that, when the two of them are together downstairs, to put it into context. One of the other concerns is the use of this text messaging, not just through the witness that's testifying, but to bolster each other's testimony or to bring in somebody else's statements through another person. So I think that it's important when the court analyzes if this is really an excited utterance to look at what's being said, as well as to understand the context right before and the context right after, not the next morning, the one's continuous, but right after.
Well, there are several things that I have to look at. One is, first of all, is it hearsay? Is it an assertion, right? So is it offered for the truth of the matter asserted? We get to those two things. Then we look at, is there an exception? For each of those two things, it generally means it's an out-of-court statement. Then it's, unless otherwise definitionally excluded, hearsay. Unless there's an exception, then the exception being the excited utterance, and then we look at the surrounding events. Is it common or current present sense impression? Look at the surrounding events, what's said. Much of it is not assertions necessarily, or I would imagine some of it not offered for the truth, but simply to establish a timeline. And so I'll look at all of those things. But I don't think I can just look at the whole thing in whole and say, well, because they later on were doing things that, 19, 20-year-olds do with their phone, doesn't mean that what happened earlier wasn't an excited utterance.
I understand. Our position is that those things that happen immediately thereafter impact the nature of those text messages that occurred between the two.